viewing.
Hello there. The issue of land dispute or conflict is one of the most emotive ones in the country, and that's the reason why today on this episode of the Realtor Show we'll be talking about that and how one can help themselves, or rather help to protect themselves and their interests when it comes to such deep issues. And that's the reason why I'm joined by an advocate of the High Court, that is Joseph Mugweru, who will be telling us how to resolve such issues. Karibu sana to the show.
Thank you very much.
Mm-hmm. As I've just mentioned in my introduction, the issue of land disputes and conflicts is one emotive issue, so much so that we even have a different court altogether put up just for that. What are some of the things that one can do to protect themselves and ensure that they are not caught up in such disputes as a property owner?
I think the first thing a property owner should do, and this is the most important thing, is to make sure that when you're buying land or when you're purchasing land in Kenya, you follow the right procedure, you instruct the right person to take you through the process. That is, you have to get an advocate of the High Court who is well experienced in matters conveyancing, and is going to help you sort your land issues, and that is how you will be able to protect yourself in case there is a dispute in future. Yes.
I'm going to ask you a very personal question. You are an advocate of the High Court. But the issue of digitization has brought a lot of issues back and forth with the Law Society of Kenya, saying once this goes fully mainstream, our members, and especially those in the area of conveyancing, are going to lose their daily bread. And that's what I'm saying. It's quite personal because you're involved. I just want you to touch a bit on it. I know there have been some issues on digitization, especially in the Nairobi registry, but just touch a bit on it.
Okay. The issue or the idea of digitization was a very good idea, but the issues that are coming up is that in the implementation of the idea is very slow, and currently the digitization is affecting most transactions in land, especially in Nairobi area, especially in the area of Dagoretti. So it's not that advocates are against the process because we will lose our. Don't forget also we have to do the contracts, that is the documents that convey this land, the transfers. We are the ones to do them. We will not lose our land. The issue is on the area of digitization is it's slowing our processes. Members or our clients cannot get loans because before you get a simple search, especially in the Nairobi registry, it takes ages. How will our clients continue with their businesses if this process is taking slow, or the process is very slow? So that is the only issue we have with it. We have an issue with its implementation, and that is why most members of the Law Society are of the opinion that the process should be done, including all stakeholders, and I think it would be best it's done in phases as they did the citizen, and that is why most of it is working efficient.
Let's now dig deep into the issue of land grabbing in the country, and I'll give you a scenario. Let's say there's a property owner who has a property that is a leasehold, and the lease is about to expire, but then again the people who are privy to such information fail to remind them to renew their leases, and it expires and that land goes. That's land grabbing basically, right?
Not really. It's not land grabbing because you have a lease. It is your responsibility to make sure and track the number of years your lease is valid. So in case it expires and you don't take the right steps to renew it, then you should not come back and blame people that, okay, it's quite gangster, if I may use that name, but at the end of the day is that you have a responsibility. Issues of land grabbing mostly happens when I have my land, I have my title deed, a private developer, as we call them in this country, comes in, develops on my land without my consent or without me knowing, or have a title, or is issued with another extra title deed apart from mine. That is now, yeah, it's called, that is not even double allocation. Oh. That is just land grabbing. Because at the end of the day, one title, for you to be issued with another title in connection to a particular land, you have to go through the whole process of transfer and conveyancing. But you get scrupulous dealers at the Ministry of Land, some who don't even work there. They tell you, we'll give you a title to this land. That is basically what happens, or that is what we call land grabbing, where you take someone's land without their permission, without following the right procedures as set down in the law, and you start developing in it.
So let's say that happens to someone. Let's have it as a practical scenario. That has happened to you.
Okay.
Your land has been grabbed, and there's some development on that area.
Okay.
What now happens? And let's just say it's a story high building. What happens?
The first thing I would advise anyone who goes through that process, the first thing is that you should rush to court and seek an injunction to stop the development on your land. Secondly, it would be prudent to have a caution or a caveat on that land, preventing any other developments or any other types of conveyancing from being done on the said land as the case continues. So it will be now up to you to rush to court, get an injunction, stop, that is under certificate, stop the development, and hope that the whole process will go on to the end when the court will speak themselves or decide on whose land it is. Yes.
Let's say before the court process itself of the matter, and you, as you're saying, because property owners would want to have to advance themselves economically. Let's say you want to have a loan, but then there's a development in that area, and the court is taking ages before it resolves the issue. What are some of the other ways or out-of-court settlements should people engage to ensure that both parties settle it amicably?
The Constitution recognizes what we call alternative dispute resolution. You can go through arbitration or mediation where parties come together. You talk, you say that this land is this is the process that used to acquire this land. You have two options. You either buy the land or exit from my land. You know, such agreements where the parties that are in dispute can talk out of court as the matter goes on in court, but it should be in the background. So you can talk to the person who has grabbed your land, or the person that has grabbed the land can talk to the owner. If they are willing to sell, well and good. If they are not, we'll have to wait for the court process to end.
Okay, so Wakili, could you kindly take us through the different types of land disputes that you've probably come across practically?
So currently, most land dispute first comes from what you've just explained. People having two title deeds to the land. Everyone has a title deed which they claim is an original title deed. Secondly is where there is succession and there is an issue from the family that no one wants to agree on the borders and everything concerning their land. That is another source of dispute. Also, there is also another dispute that a person has taken a loan from a bank, for example. The guy has defaulted, or there are some issues with payment. So the bank wants to exercise its power of sale under the charge, of course. You can rush to court again. That is another source of dispute. Maybe someone will go and say that I have not been paying because of this. It is for the courts to decide. Also, there is what we call nowadays compulsory acquisition of land, where the government will want to take land from a person to develop it for public use. And I have to be very clear here. Public use.
In fact, yes. That is one of the areas I wanted us to touch on, the compulsory acquisition and the powers that the government has. But thank you for taking us through the different types of land disputes. Now, let's talk about that compulsory acquisition of land by the government. We've seen scenarios in the country where private individuals know that a certain project might be set up here by the government, and then they inflate the costs of that property. So what happens here?
Don't forget, when government wants to acquire your land, there is what we call a market value, and it's for a valuer who is a person who is experienced in that area to come and value your land and say this land costs this much. The only instance that I think you would look at is when I know that there is a project that is coming along a certain road. I rush to buy that land myself, not taking advantage from the locals, and then now I come and inflate the price, because of that project. That is an instance where now the courts will have to determine what is the market value, or Lavalwa will have to determine what is the market value of this land to enable the government pay you. Because at the end of the day, don't forget that this money is coming from our taxes. The government cannot just pay you that way. So the evaluation report has to come before court or before the National Lands Commission, which is going to authorize the payment according to the market value, not what you want. It's not about what you want, it's what the market value is at that time, not in future, at that time. Yeah.
So Wakili, let's say there's a dispute between a private citizen and the government. What does the law say? Does the law say that the government prevails in such a situation, or the law also protects the mwananchi?
You have to know that everyone in Kenya has a right to property under Article 40. And in case you feel like the government is about to infringe or has infringed on this right, the best place to go is to go to court. And this being a different arm of government, the court is going to sort this dispute. It's not that the government will prevail, because a lot of Kenyans have this mentality that you cannot sue the government. Indeed, you can take the government to court and say that this land was my land, they want to take my land, yes, but it's not to be used for public purpose. So that is the only place where you can sort your dispute between the government, which mostly is the executive government, and yourself as a private citizen.
Okay.
Yes.
Well, thank you very much. Well, on this episode of The Realtor, we're talking about land disputes. When we come back after this short break, I want us to touch on succession. So don't go away, keep it here.
You are watching TV 47, the home of untold stories. Told stories.
Welcome back and thanks for staying with us. This is The Realtor Show, and I'm sitting in for Robert Ndongo. My name is Eric Munene, and in this episode, we're talking about land disputes, and with me here to discuss that is Joseph Mugweru. Wakili Joseph Mugweru is a conveyancing advocate of the High Court. Sir, before we went for that short break, we had promised our viewers that we're going to talk about succession. What happens, and especially on land matters, what happens now in succession matters that, one has property, but they unfortunately died without leaving a will? So what happens to solve such issues?
Okay, it's not a big issue per se. The law or the framers of our law foresaw that, and that is where you are allowed to go to court and get what we call, or you are issued with what we call grants that allow you to be administrators of an estate of a person, of that person who died. When you get those grants, you have to take those grants and fill some forms that are provided for in the Lands Registration Act, and after that, that is when you launch an application for transfer of that property to the rightful successors of the said properties. So if let's say you have a person has a property and the land has to be transferred, you just have to fill those forms and launch them with a death certificate and that order. And what will happen in land law, we call it transfer by transmission. In this instance, don't forget, you will not be required to pay what is formally known as stamp duty, because the transfer is happening because of transmission, and such a transfer is exempted from stamp duty in law. Yes.
Okay, so now we are in court. The court is ready. Both parties, or the involved parties, are now in court. They've gone to court because of this dispute. So what happens now? Take us through the process.
So you are in court. The first thing is that you are issued with letters of administration, where the said estate there is a notice issued at the Kenya Gazette for 1 month, and then after 6 months. After 6 months, there is what we call confirmation of those letters. As you wait for those 6 months, it's for the now parties or the family members to agree how property will be distributed, and then have that document launched in court for the court now to call them in a particular day, and we'll ask them, so and so, do you agree to the distribution of this property? So if you are given property A, then that property, now it's up to you now to transfer that property to yourself. Yes.
And what happens now in cases where, because now you're saying the court says it is at the discretion of the parties involved, what happens now? We've all gone home, the parties involved have gone home, but there's still a stalemate. One party wants this done, but the other party is opposed to that. What step now is taken to solve that stalemate?
The next step is for the court to step in and solve this dispute, because now if family members cannot agree, then it's up to the courts now to solve disputes, as it's their core mandate to solve disputes within the republic. So it's now, we will require now the court to come in, and the court will hear each party and make a decision on how a transfer will happen, or who's going to be given this property or such a thing. It's for the court to decide, or to come in and help you if you cannot solve this dispute.
Now let's talk about the Environment and Lands Court. Earlier on you mentioned about the alternative dispute resolution mechanisms. I remember the former Chief Justice Willy Mutunga really advocated for it. What kind of cases are now taken to the Environment and Lands Court?
So in the Environment and Lands Court is a court that was established as per Article 162(2) of the Constitution, that requires Parliament to enact an Act of Parliament to create courts that are going to deal first with industrial disputes, that is employment issues, and also matters land and environment. So the court is established under Section 4 of the Environment and Lands Court Act, that this court is a court that solve any dispute that relates to land, that is management. Let's say there are 2 title deeds, it's for the court to decide which title deed is real and which is fake, or which takes precedence. Let's say there is the issue of compulsory acquisition of land. It's this land that handles these disputes. There is also another thing called adverse possession, where the law allows a person to say that this land is mine if you stay in that land for 12 years uninterrupted and the owner does not come. So when you give that, when the adverse possession issue is raised, it's for this court to sort it out. So initially, before a decision, a landmark decision was made, that is the Malindi case, this court had, people thought that this court had exclusive and original jurisdiction. By exclusive, I mean this court, you would start your land disputes. If you had a land dispute, you will go to this court to solve it out, and no other court below it would solve it. But after the Malindi case after there was the Court of Appeal decided the Malindi case, a bench of 5 judges, then now even the lower court, that is the magistrate court, can have audience if you think there is a matter's land that you need to solve, and then the matter is below what we call in law pecuniary jurisdiction. That is the pecuniary jurisdiction, we mean it's below 20 million. So the magistrate court can now hear such matters. But initially, it was only the Lands and Environment Court that would hear such matters. So this court has the equal status of a high court. So if a decision is made in this court, the only other court that you can appeal your decision is the Court of Appeal and not the High Court. So the Constitution gives it equal status, as it says. So this is the land that basically has the jurisdiction to determine any dispute in land and environment use. And also if your rights, constitutional rights in connection to land has been violated.
Okay. You've mentioned something very important here about the adverse possession of land. And I want us to have a practical scenario. You have landless people. They're usually called squatters. They've occupied a piece of land for, say, 13 years,
yes,
uninterrupted,
yes,
by the owner, by the simple reason that the owner or his or her representatives did not know of the existence of the land. But then now, on the 13th year, they come and they want to take back their land. What happens in such a case?
These people have, these other people that need to take the land, or the owners, you have neglected your property for a cool 13 years. You've not come back to check on your property. The court cannot help you on such a case. Your property is as good as gone. These courts will just have the order of adverse possession, and unless now you go to court and the court is going to determine why you never came back to your land, then your land is as good as gone.
And how can the squatters prove that yes, they've been there for such a period to warrant them have that adverse possession law favor them?
It's just simple. In a court of law, we use evidence. I'll just call witnesses. Mostly it's witnesses. I have these witnesses who say that we've been seeing this person in this land and we don't know even the owner. So even this person who is saying this land is his, we don't know if he existed. So mostly the courts will rely on evidence and evidence from people. Yes.
Let's talk about now the alternative dispute resolution mechanisms, yes, and especially those that touch on land. Are they really legally binding? Say the chief at your rural area has stepped in, or the local elders have stepped in to solve a dispute. Are those legally binding?
They are binding, but I'm not going to say they are legally binding, because if I'm not contented with the decision the chief gives my client or myself, I have the option of court. And mostly these disputes, the chiefs take over, or the elders takes over, is mostly happens to be the border disputes. If you're not contented, then you can go ahead and ignore the said decision and maybe move to any other thing that you think will be maybe a court of law that is going to give you a fair decision in your opinion. But the same are not binding, because it's the jurisdiction of our courts to determine issues to do with lands. Yeah. So,
Wakili, take us through, now there's a dispute, there's a land dispute. Take us through when a dispute, the court deems a dispute as one that has emanated from a criminal activity, or when the court now decides this matter is just civil. When does the court decide now this is criminal and it should be dealt with in a criminal way, or rather this one should be dealt in a civil manner?
Most land disputes in Kenya are mostly civil, but that does not stop you from having these two matters running concurrently. For example, if there is someone who forged my signature, that is forgery under the criminal law. the court can actually let the criminal law continue, or the criminal courts continue with the same dispute as the same dispute is being had in the civil law, in the civil court. It does not prohibit any person from running two cases, that is concurrently, a criminal case and a civil case. So there is no really border of between what is criminal and what is civil. If I think my matter is criminal, and both criminal and civil, I will go through it with the two ways, and no one can deny me that right, remembering that I have the right to access to justice. And if I think my justice would be in the criminal court and civil court, then well and good.
The reason I'm asking you this is because we've seen in news people being duped, investors being duped by land buying companies, and the directors, the said directors, allegedly just disappear into the thin air. So what kind of reprieve do such investors have in the court of law?
The first thing is that such a person, if let's say I'm duped, the first thing is I should report it to the police. And it's the police now to investigate, right? And in the same time, if I have the capability, because at the end of the day, don't forget, litigation is expensive. I can walk into a lawyer's office, explain my situation. The lawyer drafts, an advocate drafts the pleadings to go to court, and then we just go to court. That is the most logical remedy a person who thinks he has been duped can have on these people. Yeah.
Wakili, as we wrap up, I want your final submissions. To hear your final submissions right here on this Realtor Property Show. Advice to potential investors who might find themselves duped. So, what can you tell them?
If you find or realize you've been duped, kindly contact an advocate of the High Court who is going to help you navigate through both the criminal, if you want, and civil cases. Don't forget that nowadays, even if you are a complainant in a criminal case, you are allowed to have an advocate to watch brief for you. And this advocate would be reporting what is going on in the criminal case as he goes on with the civil case. So at the end of the day, advocates are very important.
Well, thank you very much, Wakili Joseph Mogero, for that informative session. Asante sana. Well, that has been Joseph Mogero, an advocate of the High Court, a conveyancing expert. We're talking about land disputes and conflicts in the country. It's a very emotive issue in the country on this episode of The Realtor Show. And thank you so much as well, the viewer, for watching. This has been The Realtor Property Show. My name is Eric Munene, sitting in for